SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to lecture number 18 of our course on law of copyright, patent, trademark and other IP. The present lecture will be on passing off remedy under trademark law. By now you are familiar with the basics of trademark law as to what is the meaning of trademark, what are the various kinds of marks which are there in the Trademark Act, what do we mean by distinctiveness. We had a full session on registrable marks, if you recall. We said our law does not provide a list of registrable marks. In fact, it gives a list of prohibitions as to what all marks are not registrable. And we said the marks are not registrable if the prohibitions mentioned in sections 9 and 11 exist. So, in relation to any mark, if prohibitions of 9 and 11 do not exist and that mark otherwise fulfills the requirements mentioned in the definition of trademark in section 2, such a mark is registrable, and I mentioned this point that this expands the scope of registrable marks. Then we talked about infringement, but before that we referred to something called as well-known trademark also. We understood the factors which shall be used to determine whether a mark is a well-known mark or not. Then we had a full session on infringement of trademark, in which we understood the concept of possible confusion in case of infringement. Similarity itself may not be bad unless it is a deceptive similarity. That similarity which causes deception is the point of concern. We also discussed the kinds of infringement: contributory, vicarious. We discussed the various exceptions in relation to actions of infringement, under what circumstances the acts may not be considered as infringing acts. We have to understand that the law does not require that all the marks must be necessarily registered. I mentioned this point in one of the classes that you must be familiar with two symbols. One is an R written inside a circle and the other is TM written inside a circle. Obviously, R indicates that the mark in question is a registered trademark, whereas TM indicates that although it is not a registered trademark, but still the proprietor, the trader is using it as trademark in the course of trade. We said that it although does not require all the marks to be mandatorily registered, but the benefits of Trademark Act 1999 can be claimed only once you register your trademark. And that is what you saw in the last lecture. Only the proprietor of a registered trademark can file for infringement. Using the mark and filing for infringement is something which is exclusively allowed for a registered proprietor. But now in this lecture we will be trying to understand as to what shall be the remedies in case rights of proprietors of unregistered trademark are violated. And for that we have a separate remedy called as passing off remedy under trademark law. This is what we are going to discuss in the present lecture. You must be familiar, those who have done tort law must be familiar that passing off is a common law tort. You must have studied the tort of misrepresentation. This is the same thing which we are going to do under Trademarks Act. What do we mean by passing off? Now, if you see, Passing off occurs when illegal use of a trademark is in such a way that public is misled to believe that the products or services supplied by one party are genuinely those of another. It is definitely an illegal use of trademark. This illegal use is done in such a way that you mislead the public to believe that the products or services which you are supplying are actually the products and services supplied by somebody else. Now, this misrepresentation can harm the goodwill and reputation of the legitimate trademark proprietor, trademark owner. So, we are talking about something called as misrepresentation, the tort of misrepresentation. You are misrepresenting the whole thing in such a manner that people are misled to believe that the product, the goods, the services are originating from some other trader. So, you are trying to pass off your goods as somebody else's goods. This is the basic idea of passing off. As I said, this misrepresentation has the potential to harm the reputation, to harm the goodwill of the legitimate owner of trademark. Goodwill itself is an asset. Goodwill itself is an asset. Goodwill is that force which attracts customers towards business, and it takes a lot of time and investment to create the goodwill. Passing off has the potential to undermine the goodwill or tarnish the goodwill or harm the goodwill of the legitimate owner of the trademark. And what notion of passing off does, the concept of passing off does, it seeks to save this goodwill which is associated with unregistered trademarks. So, therefore, unregistered trademarks are not unprotected trademarks. In passing off, person offers products or services under a deceptively similar mark to another's existing mark. There is an existing mark. I am offering my products under a mark which is deceptively similar to the existing mark. This is the crux of passing off, as a result of which I am causing people to believe that the goods are originating from some other trader. So, I am using a mark which is deceptively similar to some existing mark, and therefore it causes confusion, and therefore it dilutes the distinctiveness of the original trademark. This is what we called as passing off. These are the consequences of passing off. The main idea is, by way of the mechanism of passing off, we try to safeguard the goodwill which is associated with the unregistered trademark. As I said, unregistered trademarks are not unprotected trademarks. Passing off occurs when a person sells his products as the product of other person. Now, let us see what is passing off. Passing off occurs when a person sells his products as the product of other person, and the other person, the original trademark owner, takes legal action against such act. It is very simple. The concept of passing off was developed in the case of Perry versus Truefitt. You see, it is here. It is an old case of 1842, where the court held that a man is not to sell his own goods under the pretense that they are the goods of others. So, you are passing off your goods as somebody else's goods. That is the meaning of the concept of passing off. It was developed in the case of Perry versus Truefitt, 1842. In passing off remedy, the claimant must demonstrate the possibility of public misunderstanding, because it is essentially a misrepresentation which leads to public misunderstanding about origin of the product or service. You make people to believe that the goods are originating from some other source. As I already mentioned, that the basic idea of passing off action is to protect the goodwill of original owner. The fundamental question in passing off is whether defendant's behavior possibly harms the plaintiff's goodwill. This is the key word. The passing off is an actionable wrong under law of tort. The very first thing which I mentioned, it's a common law tort. Passing off is an actionable wrong under law of tort wherein a person passes off his goods as the goods of another to exploit the goodwill and reputation in his business. Law of tort dealing with passing off the goods is substantially based on judicial decisions, as you may be aware. We do not have much of codified law of tort. Same is the case with tort of passing off, tort of misrepresentation. It is substantially based on judicial decisions. The Trademark Act deals with only the rules of procedure and remedies for passing off. The fundamental common law principles still hold good, right? So what I am trying to say, as part of law of tort, it is still relevant. What Trademark Act does, it only provides the rules of procedure and remedies for passing off. So this is the meaning of passing off. Let us see how we deal with this concept within Trademarks Act 1999. As it is, passing off is not defined in the Act. But the law recognizes the common law rights of a trademark owner, wherein the owner can initiate legal proceedings against any person for passing off goods or services at the goods of another person, section 27. So, although section 27 does not define what is passing off, still law in section 27 recognizes the common law right, this common law right, and this common law right of initiating legal proceeding against somebody who is passing off goods as the goods of another person is recognized here, section 27. We don't have a definition. It says that no person shall be entitled to institute any proceeding to prevent or to recover damages for the infringement of an unregistered trademark. I already mentioned that law does not require that all the trademarks must be necessarily registered. It is only that you can file for suit of infringement. You can file for infringement if your mark is registered. That is what has been mentioned here. No person shall be entitled to institute any proceeding to prevent or to recover damages for the infringement of an unregistered trademark. So there is no remedy if an unregistered trademark is infringed. There is nothing like infringement of unregistered trademark. Because there is nothing like infringement of unregistered trademark, so therefore the Trademark Act provides for something other than infringement proceeding in relation to unregistered trademark. The Trademark Act shall not be deemed to affect rights of action against any person for passing off goods or services as goods of another person or as services provided by another person or the remedies for unregistered trademark. This is crucial to note that although the Trademark Act does not provide for the remedy of infringement for unregistered trademark, it says that the law does not affect the passing of remedy. So for unregistered trademark owners, law recognizes the passing of remedy. It leaves it unaltered. It does not affect the passing of remedy for unregistered trademarks. So it is very clear now, for registered trademarks, the remedy is there in the form of infringement action. For unregistered trademark, the remedy is there in the form of passing of action. So therefore, it is a mechanism of protecting unregistered trademarks in order to prevent unfair competition, because if you leave this section unaddressed, if you leave the whole section of unregistered trademarks unaddressed, that will lead to unfair competition and that will be harmful for consumers. Passing off reflects the changing nature of unfair commercial practices as well as the necessity to protect against misrepresentation in economic interactions. It is just to recognize the remedy of passing off. That is why law recognizes the remedy. So, if your mark is registered, you have the benefit of claiming the remedy for infringement. But if your mark is unregistered, even in those cases, as I mentioned, the law recognizes passing off remedy. Now, what are the essentials of passing off? The essential characteristics of passing off required for valid action include, the first thing is misrepresentation. As I said, it is essentially a tort of misrepresentation. A misrepresentation which is made in the course of trade. A misrepresentation made by a person in the course of trade to prospective, kindly read as prospective, to prospective consumers of his goods or services provided by him. So, there is a person who is in the course of trade making representation to consumers regarding goods or services provided by him, which is calculated to injure the business or goodwill of another trader and which actually causes damage to the business or goodwill of that another trader, who will bring an action of passing off. So, these are the essential ingredients of passing off. Misrepresentation, a misrepresentation made in the course of trade, a misrepresentation made to the prospective consumers in relation to goods and services, a misrepresentation made in order to injure the business or goodwill of another trader, and a misrepresentation which causes actual damage to that actual trader, the original trader. Now, if these essentials are there, the tort of misrepresentation is proved, the tort of passing off is proved. But defendant is not without any defense. There are certain defenses which the defendant can raise during the action of passing off. These are some of the defenses you see. The first is, the defendant can say that the mark or name which is sought to be restrained is devoid of distinctiveness. I may have copied it, that's a different thing. First of all, let us see what is your trademark. Your trademark itself is devoid of distinctiveness. If you do not have a distinctive mark, you do not have the standing to file for passing off. Second, the use of defendant's mark or name is not likely to pass off as those of plaintiff's goods. In practice, actually, I am not passing off my goods as your goods. This is the second defense. Third, the goods or business of the defendant is totally different from the plaintiff. You are selling something else under your mark. I may be using slightly similar mark, but my product, my goods, my services are entirely different. Next, defendant has not misrepresented with facts or harmed the goodwill of the plaintiff. I am not harming. There is no reduction in goodwill. There is no depreciation in the value. And the last is, plaintiff is not entitled to relief on account of maybe delay, estoppel, acquiescence. These are equity based. These are equity based arguments. So, these are the valid defenses which defendant can take up in an action of passing off. I mentioned what are the ingredients of passing off. I also mentioned what are the defenses the defendant can take. Passing off can be of different categories. Different categories of passing off are reflecting the ways in which trademarks can be used unlawfully to cause confusion and impair the goodwill. There can be direct passing off, there can be indirect passing off. Direct passing off occurs when a person intentionally uses an identical or deceptively similar mark. direct passing off entails a purposeful misrepresentation of the origin of the product or services, which damages reputation of the original trademark and distinctiveness. Whereas indirect passing off occurs when party uses a trademark, although not identical, but creates confusion with other mark. So that is how you decide whether it is a case of direct passing off or indirect passing off. Indirect passing off, personal intentionally uses identical or deceptively similar mark. The misrepresentation is purposeful so as to damage the reputation of original trademark. Whereas indirect passing off is a situation where you are not using identical trademark, but somehow you are causing confusion with the other trademark. It generally happens due to slight similarities. We are talking about indirect passing off. Indirect passing off is a case where you are not using identical trademark, but some confusion occurs because of your use. That happens because of slight similarity in the overall impression of the marks and causing consumer to credit products or services to the wrong sources incorrectly. The overall impression of your mark is similar to the overall impression of the plaintiff's mark. So you are not using identical trademark, still because of slight similarity in prominent aspects, there is confusion that leads consumers to credit your products as somebody else's products. So source becomes, it's a wrong source which is determined by the consumers. Indirect passing off presents difficulties in determining misunderstanding and the subsequent impairment of goodwill of the original mark. This is the difficulty associated with indirect passing off. Indirect passing off is where the marks are slightly similar. The confusion is because of overall similarity in the impression which is formed in the mind of public. And if that is the case, there are difficulties in determining the loss of goodwill, the impairment to the goodwill. So first is direct passing off, second is indirect passing off. There is this third category called as reverse passing off. As the name suggests, it happens when a trader replaces the products of trademark owners and rebrands them for sale as their own, making the public believe that the goods are its own. Passing off means I am selling my goods under your brand name. Reverse passing off is I am selling your goods under my brand name. In both the cases, goods are being passed off as somebody else's goods. But what happens in passing off, I get the benefit of your goodwill. When I pass my goods as your goods, I get the benefit of your goodwill, your reputation. In reverse passing off, if you see, in reverse passing off, I am selling your goods under my brand name. And in this case, the public would come to associate the qualities of the trademark owner's product with the substituted product, and the original trademark's goodwill would become diluted over time. You understand? This is your package. This is my package. I exchange the goods. My inferior goods are sold here with this brand. Your superior goods are sold with my brand. And gradually the higher quality, the superior quality will lead to enhancement of goodwill for my brand, and the inferior quality will gradually lead to reduction or dilution of goodwill of the original trademark brand. This is what happens in reverse passing off. So we understood what is direct passing off, what is indirect passing off, what is reverse passing off. Now let us see what are the criteria for establishing passing off. The criteria for establishing passing off are, first, you see, goodwill and reputation. Proof of goodwill and reputation of unregistered trademark is must to get passing of remedy. The claimant has to establish that the trademark in question has acquired distinctiveness resulting from the reputation and goodwill. So, the first criteria is goodwill of the unregistered trademark, the reputation of that unregistered trademark. I have already explained that goodwill is that force which attracts customers towards business. So, that is something which the owner of trademark, the unregistered trademark, will have to establish. He has to establish that unregistered trademark has acquired distinctiveness resulting into formation of reputation and goodwill. The second point is misrepresentation. It's a sine qua non. The whole idea is that it is a tort of misrepresentation. Misrepresentation means unauthorized use of a trademark that confuses consumers about the trade origin, the origin of products or services. So, first is goodwill, second is misrepresentation. The claimant must show that defendant's action have or are likely to cause public association with claimant's trademark. So, this is misrepresentation. The third criteria, the third ingredient is damages. That means in addition to proving confusion, deception, likelihood of confusion, the claimant must also establish actual or potential harm. This harm can be financial loss, can be reputational harm, can be dilution of distinctiveness of trademark, can be dilution of goodwill. So, for proving passing off, such dilution, such reputational harm, financial loss, actual or potential harm is to be established. So, there are 3 points which are important. You prove goodwill in your favor, you prove misrepresentation done by the wrongdoer, the defendant, and you prove actual or potential harm because of the misrepresentation. An important aspect of tort of passing off is deceptive similarity. You are using a mark which is deceptively similar to my mark. And how do we decide deceptive similarity? You have a list of factors which can be used to determine deceptive similarity. The first is nature of marks, whether the marks are word marks or label marks or composite marks, that means containing both words and label. So, whether the mark which defendant is using is deceptively similar to plaintiff's mark, that will depend on the nature of mark. Second, degree of resemblance between marks. Degree of resemblance between marks, deceptively similar. What kind of deception? Deception may be phonetic deception. The similarity may be phonetic similarity. The similarity may be in terms of idea which the mark conveys. So, therefore, what is the degree of resemblance between the marks? Whether it is a case of phonetic similarity, whether it is a case of similarity of ideas. The third factor is nature of goods in respect of which they are used as trademarks. The nature of goods in respect of which they are used as trademarks. Are we using these marks to sell cattle field? Obviously, who will be purchasing cattle field? People who are relatively less literate. For them, deception is more easy as compared to those who are maybe more literate. So, whether similarity is deceptive will be determined on the basis of nature of the mark, degree of resemblance, nature of the goods in respect of which they are used, the similarity in nature, character, performance of goods of the rival traders. The two traders are selling goods which are similar in nature. The two traders are selling goods which are similar in character and performance. Chances of deception will be very high. Next, which is related to one of the previous points, is the class of purchasers who are likely to buy the goods bearing the marks. Their education, intelligence, degree of care they are likely to exercise in purchasing or using the goods. Who are the purchasers? Whether they are literate people, whether they are illiterate people, people from rural background. So all these factors will be important because deception is a question of fact in a given case. Despite similarity, there may be no deception. Next, the mode of purchase of goods or placing orders for the goods. Do you get an opportunity to look at the mark before you actually order, before you actually purchase? If you do not get an opportunity, you only purchase on the basis of brand names which is told to you, there are chances of deception. Any other surrounding circumstances which may be relevant in the extent of dissimilarity between the competing marks. So therefore, these are the important factors to decide whether the similarity is deceptive or not. Let me again quickly tell you, it depends on nature of mark, it depends on degree of resemblance. I said keep in mind, similarity need not be in appearance only. There need not be only visual similarity. Apart from visual similarity, there may be phonetic similarities, sound alike. There may be similarity in terms of idea which is conveyed. I said nature of goods which are sold, the nature of similarity of goods, who are the purchasers who are likely to buy the goods, what is their qualification, and what is the mode of purchasing the goods. These are the factors, and weightage will be given to each of these factors depending on the fact of each case to decide whether similarity is deceptive similarity or not. There is a case called as N.R. Dongre versus Whirlpool Corporation 1996. The appellants got registered the mark Whirlpool in respect of washing machines. Whirlpool Corporation filed a suit for passing off because Whirlpool Corporation did not have a registered trademark in India. Since their mark was not a registered trademark, they only had an option to file for passing off to restrain the appellant from manufacturing, selling, advertising, or in any way using the trademark Whirlpool. So this was the case filed. And the first objection could have been when, see, the appellant got registered the trademark Whirlpool, and Whirlpool Corporation is not the registered trademark owner, and a passing off action is filed against somebody who is the proprietor of registered trademark. Is it possible? This is the first question which I wanted to raise. Can a passing off action be filed against the proprietor of a registered trademark? That is the question. And court held that passing off action was maintainable in law even against registered owner of the trademark. Court said that this word Whirlpool is for long associated with Whirlpool Corporation, and Whirlpool Corporation, even if it does not have any presence in our country, it still has cross-border reputation, trans-border reputation. Now this is the main outcome of this case, that passing off action can be initiated against the proprietor of registered trademark also. You cannot say that a particular mark is registered in my favor, then no passing off action can be filed against me. That is not true. In an action for passing off, it should not matter whether misrepresentation or deception has proceeded from a registered or an unregistered user of a trademark. Whether the person using his trademark is a registered proprietor of that trademark or an unregistered proprietor, that is immaterial. Passing off action is very much maintainable even against proprietor of a registered trademark. We discussed infringement in the previous lecture. We are talking about passing off now. Let us try and understand some of the differences between passing off and infringement. The first point is, while an action for passing off is a common law remedy, being in substance an action for deceit, a tort of deceit, a tort of misrepresentation. That is, a passing off by a person of his own goods as those of another. This is not the gist of an action for infringement. The action for infringement is a statutory remedy conferred on the registered proprietor of a registered trademark for vindication of the exclusive right to use of the trademark in relation to those goods. What right does registration confer on the proprietor of a trademark? The right is exclusive right to use the trademark. And if this exclusive right to use the trademark is violated, you got a standing in statute to file an action for infringement. So therefore, these are two entirely different proceedings. First, the essence is I am trying to pass off my goods as your goods. Second, the essence is I am exercising a right given to you. So while an action for passing off is a common law remedy, being in substance an action for deceit, that is, a passing off by a person of his own goods as those of another, that is not the gist of an action for infringement. The action for infringement is a statutory remedy conferred on the registered proprietor of a registered trademark for vindication of the exclusive right to use of the trademark in relation to those goods. So this is the key to the action of infringement. This is key. The right given is right to use the trademark. Infringement means somebody else is using the trademark. So therefore, use of plaintiff's mark by defendant, use of plaintiff's mark by defendant is a must in a case of infringement. Try and understand. I said the essence of passing off is that I am trying to pass off my goods as your goods. I can do it by a number of ways. Using the mark is one of the ways. This misrepresentation can be done by any method. The idea is to commit deceit, to make you believe that the products originate from some other trader. So using the trademark is one of the methods to deceive you. But using somebody's trademark is not the only method to commit passing off. Whereas in infringement, because the right given is right to use the trademark, registered trademark, so infringement action will lie only when this right is violated. And therefore, I am saying that use of plaintiff's trademark by defendant is a sine qua non in the case of action of infringement. So we understand these two differences between passing off and infringement. Let's come to point number 3. Infringement of trademark occurs when a party uses an identical or deceptively similar trademark for marketing similar goods and services as that of registered proprietor, whereas the concept of passing off grants the trademark owner the right to initiate legal action against unauthorized use of their unregistered trademark. So the point is, I am trying to pass off my goods as your goods. I am using unregistered trademark in an unauthorized manner. That is what passing off is all about. Whereas infringement has a specific meaning. Infringement means the defendant is using identical mark or a similar mark which causes deception. So identity of the two marks or deceptive similarity of the two marks is a must in an action for infringement. The prerequisite for initiating an infringement action is registration, as I have been saying. an infringement action can be brought only by proprietor of a registered trademark, whereas there is no such requirement. If the essential feature, come to this point, if the essential features of the trademark of the plaintiff have been adopted by the defendant, the fact that get-up, packing and other writings on the goods or on the packets in which he offers his goods for sale show marked differences or indicate clearly a trade origin different from that of the registered proprietor of the mark would be immaterial. Whereas in case of passing off, defendant may escape liability if he can show that the added matter is sufficient to distinguish his goods from those of plaintiff. This is not something different from what we studied in first 4 grounds or first 3 grounds. If the defendant is using plaintiff's mark, and in addition to using plaintiff's mark or some mark similar to plaintiff's mark, he is also adding other content. These other content may be sufficient to prove that the trade origin of the goods coming under that packet is different from plaintiff as the trade origin. Try and understand. The additional content may be sufficient to come to a situation where there is no confusion taking place. But all these arguments will be of no use if it is an action of infringement. Because infringement is done the moment I use your registered trademark for my goods. So if I am infringing your right to use, I have committed infringement. If I am violating your right to use, I have committed infringement. Whereas in case of passing off, the defendant can take the defense that these added content leads to a situation where no deception takes place, and then he is not liable for passing off. Try and understand. The essence of passing off action is to see whether the defendant is able to pass off his goods as plaintiff's goods or not, whether there is deception caused or not. If added content can lead to no deception, no passing off is established. However, infringement is still done because what is required for infringement? Using the trademark. Then you have when a person registers a trademark and another party infringes upon it, a case of trademark infringement occurs. In contrast, if someone misuses an unregistered trademark, it constitutes passing off. These are some of the differences between infringement and passing off. If I go back to the points of difference, I said the key word is the right which is conferred by registration of trademark. The right which is conferred by registration of trademark, and that right is right to use. So infringement action, as we discussed in the previous lecture also, infringement action is mainly based on the violation of this right to use. Whereas passing off action, we will see whether he is trying to pass off his goods as somebody else's goods. And accordingly, there are these points of differences. So what we have understood by now is that passing off remedy preserves the rights of owners of unregistered trademark, and it provides for compensation for the losses occurred because of passing off. What are the remedies you can claim? The remedies can be in the form of injunction, damages. The first remedy is injunction. Injunction prevents defendant from unauthorized use of plaintiff's trademark in passing off cases. So, defendant is injuncted from making unauthorized use of plaintiff's trademark. It prevents unlawful use of trademark to protect claimant's goodwill. A party can seek an injunction to restrain the defendant from committing passing off. You have it in section 135. One of the forms of injunction is ante and pillar order. I am sure you are aware. Ante pillar order is an ex parte order allowing the plaintiff to visit the premises of the defendant to find out if there are incriminating content. It provides for partial order to investigate the defendant's premises. And this order is passed when there is a danger that defendant may dispose of the incriminating content or the item bearing plaintiff's trademark. So therefore, ante pillar orders are orders, interim measures which are passed, interim injunction which are passed to safeguard the disputed subject matter. We'll have to see whether ante pillar orders are possible under Indian law. We have the mechanism of Code of Civil Procedure within which such orders, of course not by using this name, but such orders, ex parte interim orders, can be claimed. Next is Mareva injunction. A Mareva injunction is again an ex parte order whereby the court will freeze the defendant's assets so as to prevent them from disposing of the assets so as in order to avoid the judgment. It's a very useful remedy. Mareva injunction is similar to what we have in Order 39 of CPC. So the mechanism of Code of Civil Procedure will again be useful here. So injunction can be interlocutory injunction. Injunction can be permanent injunction, the final judgment granting a permanent injunction which bars the defendant from doing activities prohibited under the passing of action. In addition to injunction, you can claim the remedy of destruction of infringing goods. The court may also issue a seizure order prohibiting the defendant from sale of unauthorized goods. The court may ask the defendant to return the goods and or destroy those goods. Plaintiff can also claim damages and accounts of profit. I have explained this point in patent, in trade, in copyright also. Damages are commensurate to the loss suffered by the plaintiff. An account of profit is the amount earned by the defendant by his wrongful conduct. As it is, you cannot claim both because these are alternative remedies. You cannot claim both of these simultaneously. How do we calculate damages? How we calculate compensation is a difficult area in IP law. I mentioned this point while discussing patent law also. So what we discussed in this session is that passing off is one of the remedies which is given to the proprietors of unregistered trademark. Passing off is a species of unfair trade competition, or it is actionable unfair trading by which one person through deception attempts to obtain an economic benefit of the reputation which another has established for himself in a particular trade or business. Now with this discussion, we have completed our segment on trademarks. We are left with 2 more lectures. The next 2 lectures shall be on law of geographical indications, law of industrial designs, and we have a full lecture on protection of plant varieties and Farmers' Rights Act. So that's all on trademark law. I have finished the 3 most important points. We have finished copyright, we have finished Patent Act, we have finished trademark law, and now we are left only with 2 lectures on other forms of IPR. That's all. Thank you very much for attending this session. Thank you.
Hi, I'm Chitwan Lalji, a PhD student of Health Economics under the supervision of Dr. Debayan Pakrashi from the Department of Humanities and Social Sciences, IIT Kanpur. In one of my essays, I am interested in understanding the relationship between consumption of fruits and vegetables and various health indicators. Health indicators, both subjective and objective health indicators like mental health, self-assessed health, various measures of blood pressure and various measures of cholesterol. Measures of blood pressure like systolic and diastolic BP, you have your incidence of high BP, MAP and incidence of high MAP. And as far as cholesterol is concerned, I have tried to concentrate more on total cholesterol, good cholesterol and incidence of high cholesterol. Now before I go on to what have been my major contributions and various policy implications, I would like to briefly tell you about the policy initiatives of WHO and various countries. The WHO, that is the World Health Organization, it started with a campaign of 5 a day. That is, you should have 5 portions of fruits and vegetables per day. That would be approximately, you could say, 400 grams of fruits and vegetables. Now, a portion, before we go further, I'll just tell you what exactly is a portion. One portion is equivalent to a medium-sized apple, or one small glass of fruit juice, which is approximately 150 milliliters, and maybe 3 teaspoons of vegetables. So, the WHO went with the 5 a day campaign, which was further taken up by various countries. Countries like UK, Netherlands, Germany, Norway, they adopted the 5 a day policy, while some went for expansionary dietary policies like France, Australia, Canada, Denmark. So, for example, Australia, it went for 2+5 policy, in which it said that you should consume 2 portions of fruits and 5 portions of vegetables per day. And USA went for a policy of fruits and vegetables more matters. That is, you must consume more and more fruits and vegetables. Now, irrespective of these expansionary dietary policies and dietary propagations, it has been found that only 28% of women and 25% of men, they actually meet the recommended dietary norms of 5 a day portion. So, the major contribution of my work is firstly to find an association between fruits and vegetables, whether there exists a relationship between fruits and vegetables and health indicators, and if they exist, whether due to heterogeneity in the data. So, I will be doing it according to age, by gender and by your weight. So, apart from that, I will go for policy recommendations, in which I am basically studying how much fruits and vegetables matter. Apart from that, which type matters more. So, for that, I have taken data from the Health Survey of England. Health Survey of England is an annual survey which takes data, which conducts information regularly on demographic and socioeconomic characteristics. You have your lifestyle behaviors like an individual smokes or doesn't smoke, alcohol consumption, you have your sedentary and physical activities, and you have various health indicators also which have been collected. Before I go on to what exactly is my research, I would like to concentrate more on fruits and vegetables, like what kind of questions were asked in the survey. Questions like, what kind of fresh fruit do you eat? Did you eat any dried fruit yesterday? Don't count dried fruits in cereals, cakes. Apart from that, for vegetables, they asked how many tablespoons of vegetables did you eat yesterday? So, approximately after this whole survey was conducted, data was converted into portions of fruits, and like for example, 3 tablespoons of vegetables is equivalent to 1 portion. So, data was converted and provided to the users, that is us, from the UK Data Health Survey. So, the major contributions of my paper is that I found a strong negative association between intake of fruits and self-assessed health, then various measures of blood pressure like mean arterial pressure, high blood pressure, systolic and diastolic BP, and your total cholesterol. Apart from that, I have found a strong positive association between consumption of vegetables and good cholesterol. So, it is recommended in a way that if you want to control your blood pressure, you must consume more and more fruits. And as far as vegetables are concerned, they impact your good cholesterol. Apart from that, I went in for a falsification test. A falsification test is basically conducted to know whether the model that you have adopted and the conclusions that you are drawing are not spurious. So, if a falsification test is done to know, in a way it is tested by seeing an indicator, a health indicator which is not being impacted by your consumption of fruits and vegetables, and then we see whether there is significant result or not. If there is no significant result, that means your model is good and your results are non-spurious. So what we did is, for falsification test, we took ear complaints and infectious diseases. Now ear complaints, like if you are deaf since birth or you have some kind of imbalance, body imbalance, that is not being impacted by your consumption of fruits and vegetables, and we did find insignificant results. Apart from that, infectious diseases like HIV, AIDS, etc., we found similar insignificant results, indicating that our results are non-spurious. Apart from that, we went, since there was a lot of heterogeneity in the data, like by gender, by age and by weight, we did the regression analysis. We found results which stated that as far as fruits are concerned, it impacts a male's health more than a female's health. So it is basically said a man should consume more fruits to impact his health, whereas as far as vegetables are concerned, they impact a women's health more. But this has been only seen as far as cholesterol is concerned, the various measures of cholesterol like total cholesterol, good cholesterol and your incidence of getting high cholesterol. Now after this, we went in for a policy implication, and in the policy implication we tried to find two policy implications: what matters and exactly how much portion matters. So as far as how much portion matters, we have found that on an average 5 or more portions of fruits impact your overall health, that is your self-assessed health, your MAP, your incidence of high MAP and incidence of high BP. But if you want to have a good mental health, so you can optimize your mental health by consuming 3 or 4 portions of fruits as well. And similarly, as far as self-assessed health and total cholesterol is concerned, an individual must consume 4 to 5 portions to optimally have the impact of consumption of fruits. Apart from that, vegetables have had a very little impact on your health. It only impacts your incidence of getting high MAP and high BP, and it's seen that only it impacts when you consume 5 or more portions of fruits. So an optimum consumption of 5 or more portions of fruits and vegetables are recommended, but fruits have a more impact on your overall health, on various measures like self-assessed health, mental health, your various measures of blood pressure and various cholesterol levels. Another thing that we find is which type of fruit matters. It has been seen that all size fruits, they impact your self-assessed health, your systolic and diastolic blood pressure, your mean arterial pressure, your high BP and incidence of getting high MAP and high cholesterol. But we find that as far as frozen fruits or canned fruits are concerned, they help in regulating your incidence of getting high MAP or high BP, but it has a trade-off. That means there is something negative happening. It reduces the good cholesterol in your body. Apart from this, if you have an incidence of getting high cholesterol, it is recommended that you must consume fruit juices, because it has a impact in reducing your probability of getting high cholesterol. And dried fruits, they impact your self-assessed health. As far as vegetables are concerned, very little impact has been seen. It has only been seen in case of portion of salads and its association with self-assessed health. Another thing that they have seen is vegetables in composite, they have an association with good cholesterol. So overall, my research basically says that there is an association between consumption of fruits and vegetables and various health indicators, and it is highly recommended that an individual, in order to be healthy, must consume 5 or more portions of fruits and 5 or more portions of vegetables per day, but fruits have a more impact on your overall health. Apart from that, all size fruits, they have a better impact on your overall health, your mental health, various measures of blood pressure and cholesterol. So, thank you.